Hello, Namaskara, good evening, and welcome to BIC Streams. Today's session, revisiting the Kesavananda Bharati judgment, its enduring impact. The judgment of the Supreme Court in Kesavananda Bharati is arguably the most important in the history of independent India. By a wafer-thin margin of 7-6, the Supreme Court laid down the basic structure doctrine, which places restrictions on the power of the Parliament to amend the Indian Constitution. In effect, this affirmed that the Constitution, not the Parliament, was supreme in India. In this discussion, Professor Sudhir Krishnaswamy and Shruti Viswanathan unpack the enduring impact of this doctrine on India's socio-political and judicial landscape. The bios of both the speakers will appear on the chat box, and at any point during the session, if you have questions, comments, or observations, please feel free to use the Q&A box. And with that, I hand it over to Shruti and Sudhir.
Thank you, Lekha, and thanks everyone for joining us today. As Lekha mentioned, we're joined today by Professor Sudhir Krishnaswamy, who is the Vice Chancellor of the National Law School of India, Bangalore. And incidentally, Sudhir was also my professor of constitutional law many years ago when I was studying the law. So it's exciting today to be the one asking him the questions. But more importantly, I'm very confident that we're going to have an engaging and fascinating session. So welcome, Sudhir, and thank you for joining us.
Thanks, Shruti, and thanks, Lekha, for getting us started.
Okay. So in September 2020, there was an obituary that sent a buzz around the legal world in India. And the obituary wasn't of a lawyer or a prominent jurist, but was the obituary of the head of a Hindu mutt in Kerala. The man in question was Kesavananda Bharati, who is probably the most important litigant in Indian constitutional history. The case that bears his name, Kesavananda Bharati versus State of Kerala, was decided in 1973 by the largest ever constitutional bench. 13 judges of the Indian Supreme Court gave judgment here. And in April 1973, the Supreme Court in Kesavananda Bharati laid down the basic structure doctrine, which stated that while Parliament under Article 368 of the Constitution has the power to amend the Constitution, there are certain parts of it which are fundamental that can't be amended by any Parliament. And like Lekha said, this makes the Constitution, not Parliament, supreme in India. The judgment itself is a tough one to unpack, partially because it is incredibly long. There were 11 separate judgments, opinions that were given as part of this judgment. And the judges didn't exactly agree on what would constitute the basic structure of the Constitution. Today's talk is an attempt at simplifying the case, at simplifying what it said. We'll discuss not just the legal principle of the basic structure, but also look at the context in which the case came before the Supreme Court and its impact on the socio-political history of India. So in February 1970, Kesavananda Bharati, who's the head of a mutt in Kasaragod in Kerala, challenges the Kerala government's attempts to do land reform acts. Basically, these land reform acts impose restrictions on the management of the religious property that belongs to this mutt. The case itself is taken up by Nani Palkiwala. What's interesting is Kesavananda Bharati never meets Nani Palkiwala. I think what is important to remember in this case, and something that Sudhir will speak to, is the litigation is as much about court craft and how do you find a good litigant to take your case to court, and how do you look at the broader impact of a specific case on the relationship between the constitution and the citizen, the court and the government, etc. Why don't you get us started and tell us a little bit about the context of basically what was happening, what is the relationship between the constitution and the Supreme Court before Kesavananda Bharati? How had the Supreme Court approached questions of constitutional amendment? And also what was happening politically in the country in the early 1970s?
Yeah. So I think we all know that we adopted a constitution in 1950, and pretty quickly citizens were in court challenging challenging legislation in the first instance, and then constitutional amendments for being unconstitutional, which is a rather curious challenge to make in legal terms, because you don't expect a Supreme Court of any sort to be sitting around adjudicating why a or how a constitutional amendment might be valid or not. That is usually understood to be a purely political decision. But the early debates in India emerged around questions of the implementation of a rather radical agenda of social transformation built around areas of land reform, some chosen industries, as well as social reform, including affirmative action and the dismantling of caste and gender patriarchy. Citizen litigants took these cases to court. The government lost. The government amended the constitution. Citizen litigants took the government to court, once again challenging the constitution, the constitutional amendment. And this occurred from the period 1950 to 1973 several times, and on at least 2 or 3 occasions. Initially, the court rejected the challenge. It adopted a position that would be quite like what the US or the British courts might do, well in line with the Anglo-American common law tradition, and declined jurisdiction over constitutional amendments. And then late in the 1960s, in an important case called Golaknath, the court took the view that it could review the validity of constitutional amendments, but it took the view that constitutional amendments would be checked against the fundamental rights chapter of the Constitution. Now, this was a curious position to take. It essentially reduced the distinction, or rather eliminated the distinction between legislation, ordinary executive action, and constitutional amendments. All of them would be checked to be compliant with fundamental rights in the Constitution. But there was a second element, that the nature of the limit that the court adopted in Golaknath was a textual limit, right? It was a part of the constitutional text that operates as a check on constitutional amendments. Surprise, surprise, the Parliament went back and simply amended those parts. It amended Article 13, it amended Article 368. It said, so you, the Supreme Court, think that these are limits on constitutional amending power. We will amend the Constitution and tell you that these are not limits on constitutional amending power. It was these amendments that came to court in Kesavananda, 1973. Now, what is important to remember, and I'm just going to connect with where Shruti was going, is that all of these early cases had a simple dynamic. It was private landholder challenging a constitutional amendment against the state, and the sort of the political dynamic that played out in the court was, here is a government which is socially progressive and socialist, some might say, and here are these rich landowners who are trying to protect their extensive land holdings. And look, the court is stalling government potentially. So the first and interesting thing that one picks up in Kesavananda is that the petitioner is a landholder for sure, but a landholder on behalf of a matha trust, a religious trust, which is a large landholder. And by bringing in the head of a matha as the lead petitioner, it changed the political dynamic of the challenge to a certain extent. And this made a difference in the way the case came to be perceived. It did not get to to it did not tend to become a case relating to religious freedom. It didn't transform into a religious freedom case, but it certainly escaped the, um, the, 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 the dynamic of the previous cases where it was a sort of landholder versus government battle. So I want to say just one more thing. The choice of the petitioner then was very important, and that choice was. We should be clear that it was not Kesavananda in some sense who originated and funded the litigation battle in this case. There were pre-existing structures of industry and landholders and sugar mills in Bombay. They had already launched previous challenges, so they kind of knew what that dynamic was. And the legal challenge was both supported by and structured by law firms in Bombay, and Nani Palkiwala's lead counsel. I think all of us know this. And it was in that sense, Kesavananda was a, was an unlikely petitioner in a case like this. Back to you, Shruti.
Thanks, Sudhir. I think in an earlier conversation, you said that he's the most important accidental litigant in the country. So now that we have a little bit of background about what's happening in the judicial landscape before Kesavananda Bharati, could you tell us a little bit more about the specific amendments that he's looking to challenge in this court? And also link it to what you mentioned earlier, how it isn't just about Kesavananda Bharati and his rights, but also other interests that want to see this case succeed.
Right. So I'm going to rely a little bit on memory here. I don't have it all jotted down, but it's the 17th, the 23rd, and the 25th amendments that we're really concerned about. I think our audience is a mixed audience, and so I don't want to get into the details of each of the amendments. But broadly put, there were two amendments that dealt with the scope of the amending power. In Article 368, the amendment said that Parliament had constituent power, and not just a limited legislative power. In Article 13, the amendment made clear that that fundamental rights do not apply to constitutional amendments. Effectively, these two amendments got rid of the basis, the foundations of the Golaknath decision. That was the background. The other amendments dealt with some property rights statutes, in particular the ninth schedule. Now, what is interesting in the way the arguments get set up is that the arguments could have been narrowly focused on getting relief for Kesavananda, right? Ultimately, here is a landholder wants to protect the ownership of their lands. But the arguments really turned, and we know that arguments went on for 68 days. At that time, the longest set of arguments in any single case in Indian constitutional history. There were councils flying between Bombay and Delhi every weekend. Very dramatic, to think about such high-profile litigation in the 1970s. Very dramatically structured and put together, and it had an array of lawyers on both sides. Arguably the lawyers on the side of government, which included H.M. Sirvai and others, were, at least as far as constitutional litigation is concerned, very, very strong lawyers. And the lawyers on the petitioner side included Nani Palkiwala and Fali Nariman, among others. And they had a lot of experience in the commercial bar, but were relatively less experienced in constitutional public law matters. That was the way the balance was structured. And while they focused on the specifics of the amendment, a lot of what transpired in the case was an argument generally about the relationship between the constitution, elected parliaments, and the court. This was really what was being worked out by parties on, I mean, by lawyers on both sides, and rather grand and theoretical debates were being had in the Supreme Court in the 70s, trying to sort this one out. Maybe I'll say one more thing, Shruti, because I think this is both important and relevant to a context like this. I think very early in the judgment, the petitioners conceded that Golaknath was wrongly decided. They conceded to the government that, look, we understand that Parliament has supervening powers. Parliament cannot be confined by the fundamental rights of the Constitution. Parliament can amend fundamental rights if they so choose. So then the debate moved not to defending Golaknath and not to defending a rather trenchant position that had developed about how a socialist government needed to be contained. The debates then shifted, the legal debates shifted to how one might draw an appropriate line of balance between the powers of Parliament and the powers of the Constitution and that of the court. So very early in the judgment, this occurred. So the temper of the arguments in this case were quite scholarly.
Got it. And how long is it between Golaknath and Kesavananda Bharati?
So 1967 is Golaknath. So 6 years later, we have Kesavananda. And Kesavananda is decided 68 days, and quite quickly, soon after that, we get an opinion. I think we know that the opinion is terribly complex. It's a plural opinion. 11 judges choose to write opinions. They split down the middle. And what we end up doing is that, and kind of good for lawyers and maybe good for law academics, then there's a cottage industry trying to decipher what did the court say. I mean, it's important to recognize that at that point in time, to write 400 pages, all put together, I mean, it's about 460 pages of the reporter, is quite a lot. Because at that point in time, in the 70s, the court is quite measured in its opinions. 20-page opinions are quite normal. And then you get this 468-pager left for everyone to figure out, the newspapers, the journalists, as well as the lawyers and legal academics all around, and no doubt the parliamentarians.
Yeah. It's the pre-Krishna year of judgments, I guess.
Yeah.
Okay, so now maybe we could walk through the judgment itself, right? Like we all know, it's quite complicated. It's 11 opinions and nobody can quite seem to agree with each other. So can you talk to us about the judgment and the majority judgment? And what did they agree upon? What did they say was the basic structure of the Constitution?
So I'm not, like I said, there's a reading the tea leaves kind of quality to the judgment, but I'll pick out a few opinions that I think would really matter in a case like this. So I think that most people know that if we were to count the numbers on the issues, there's a rough 6-6 split. And so Justice Khanna comes down in the middle. He agrees with the dissenting 6 on some points and agrees with the majority 6 on others. So in a plurality opinion, you might call Justice Khanna's view a controlling opinion. But it's not the most scholarly or thoughtful opinion of the opinions written. For the dissenting six, and I'll start there, it's Justice Matthew's opinion that is most thoughtful and well put together. And Justice Matthew essentially comes down to saying this. He says that, look, let's look around the Anglo-American world, let's look around continental European scholarship around constitutions, and let's look to our own constitutional history. Why is it that the majority cannot understand that our constitutional history demands that Parliament and the executive be given quite extraordinary powers to implement the directive principles of the Constitution, because these directive principles were the credo of the freedom movement. We achieved freedom, in other words, the national movement became a mass movement on the basis of the creed that is built into the directive principles in the Constitution. It was because the agenda of social, economic, and land reform was placed center stage in the freedom movement that we could actually achieve independence. So Matthew is very thoughtful and insightful about this part of our history. And the reason that Matthew's opinion is important in this historical context is because there's an early hagiography of the Indian court. Let me take a new book, Rohit Dey's People's Constitution, continues the same narrative. It's the narrative of the insurgent and feisty, subaltern, maybe litigant, who's going to come out and take on the might of the court in the language of the law. What is actually happening in the court? Some of that is happening, but across a large majority of cases, what is happening is that there is a majoritarian, or at least a dominant class, which is able to mobilize the court and derail social reform and land reform. And that is our inability to understand the early court to be what it is, a conservative court that had nothing to do with the freedom movement, which just happened to be career judges who continued. If there's one institution that has no break between our colonial and post-colonial inheritance, it's the courts, right? And especially the Supreme Court. It's the same people. They have the same ideas. They held office before we got independence, and they continue to hold office after. I mean, just to be clear, Matthew doesn't say all of this, but at least Matthew seems to be prescient about recognizing that this was the nature of the challenge in Kesavananda. The majority judgment, I think the best judgment I would place is Shailath and Grover. I wouldn't pick Justice Ray's opinion and Justice Sikri's opinion, which is kind of all over the place. But sorry, Ray was dissenting. Sikri's opinion, I would focus on Shailath and Grover, which was one of the concurring majority opinions. And they make a lot of progress in trying to detail what's at stake. They try to achieve some common ground with the dissent. They say land reform, it's a good thing. Land reform must happen. Social reform must happen. We shouldn't be obstructionist in constitutional transformation. But listen, there can be extreme cases. In political democracies where partial and temporary majorities run through a constitution, and they just get rid of a constitution. And in Shailath and Grover, what's interesting is that what is that image? The image is of the failure of the Weimar Republic and the emergence of fascism in 1930s Germany. So it's very clear that what that opinion threatens and warns future citizens about is that what we need to craft here is not a doctrine that threatens land reform. What we need to craft here is a doctrine that prevents an authoritarian slide. And for that reason, I think Shailath and Grover capture the point of the majority opinion far more carefully than maybe Justice Sikri does. Let me say one last thing. What did they conclude? So, I mean, this is the big question and the tough question. They concluded that Parliament had the power to amend any part of the Constitution. They also concluded that there was no quantitative limit on that amending power. You can change entire parts of the Constitution. You can get rid of some parts of the Constitution. You can amend fundamental rights, no problem. They then said, what is it that you can't do? And they said, you can't amend the Constitution in the way that damages or destroys the basic structure. You can even you can damage some values, but you can't destroy them. So they put in place the idea that with some core values, what core values, and I'll just take two or three for now: the fact that we are a democracy, the fact that we are a republic, and the fact that the Constitution is committed to some core social goals of equality, of justice, of liberty. You can't erase these values from the Constitution. And that is the position they took. They said, we can't tell you what this list of values are. We can figure these out on a case-by-case basis going forward, but we can agree today that this extraordinary power, the power to derail the republic, is not a parliamentary power. And so that's how the decisions split, at least sitting from where we sit today in 2021. That's the way I would look back and read those opinions.
Okay, I think that's fairly clear. I guess my next question is really, what's the immediate impact of this case, right? Rather dramatically, I think the day of the judgment is Chief Justice Sikri's last day in office. How is this judgment received, both by the government of the day and other lawyers and jurists in the country? Because this is quite a different position or a more strong position for the court to have taken compared to its early history with the parliament and with constitutional amendments.
That's right. It's an extraordinary judgment. It's a judgment that's so long that the court thought it necessary to put out a summary. So they put out this summary, and then the press essentially picked up on the summary and translated this to be a political warning and a political loss to the prestige of the prime minister. That's essentially how it came to be interpreted. So its immediate effect in legal terms was to be unclear enough that Parliament didn't know what to do with the judgment. There was an executive effort to try and put together another 13 or 15 judge bench that would immediately revisit the judgment. That went nowhere. It didn't have enough political capital. And then government was unsure. What are we supposed to do as a legal matter with this judgment? Look at the craft of the judgment. By not resting the limit of parliamentary power on any part of the text of the Constitution, there was no point in amending the text of the Constitution, right? So there's craft in the way the judgment was written, in that it's an implicit limit. It's not an explicit limit. So you can't amend the text. So it kind of blocked out or locked out a set of political trajectories that could have developed. I guess the medium-term impact, as we know, decision comes down in 73. The government sees it as a loss. We know now from new biographies, some of which have been discussed at the BIC, that the Indira Gandhi government on the inside had a sense of siege. They thought that popular movements which were funded from outside or supported by the Hindu right were likely to seize power, some sense of an impending coup. They also saw the geopolitics of the period, and they thought that that might be foreign intervention to seize power. And so they read the judgment as another element of that sense of siege, another ingredient. And so there was a sense in which the noose was tightening around what was a popularly elected government. And I think it's fair to say that at that point, this judgment and two others, and then finally the Indira Gandhi versus Raj Narayan election case, precipitated the emergency, the proclamation of the emergency, which took place in 1975. And so, in an immediate sense, the judgment provoked or precipitated what Justice Shelat was warning about. It was sort of self-fulfilling. He said, look, we could have the overriding of democratic government. That's exactly what happened. And in 1975, the emergency is proclaimed, and everything's up in the air. So without getting into that in greater detail, it would be fair to say that the immediate effect of the immediate effect of this judgment was to foster this sense of political insecurity.
Mm-hmm. Yeah. That's interesting because there is this popular narrative that Kesavananda Bharati is the case that saves democracy in India. But obviously it's pre-emergency, it's pre the habeas corpus case, etc. So what would your response be to people who view Kesavananda Bharati as the case that saved democracy in India?
Yeah. That's a great question, Shruti, and I suppose that the question we must ask is, why do we have sort of the grand narratives of Indian political history written in this way, which are not granular enough to the facts and the sequence of facts to kind of tease out where causation might lie? I suppose that we would have to shift to the medium term. In the near term, it would just factually be wrong to say that Kesavananda Bharati somehow prevented the authoritarian slide. Any kind of argument like this can only be made across the medium term. Because when the emergency is withdrawn in 1977, there's something dramatic that happens in the court. I think the court, the quality of self-recognition in the court and their sense of their own role in the constitutional structure clearly changes. The personalities of the court change, and what's very important, and I think Rajiv Dhawan's work and some other work by Black Shield is very important, the biography of the judges changes. Right? We get a new generation of judges into the court in the 1970s who have been brought up in a post-independence and freedom movement understanding of the purpose of the Constitution and its historical role. So by the 1970s, you see the court deliberately saying very clearly that we are not interested in locking horns with government repeatedly on these questions, that in fact we must allow the progressive goals of the Constitution to be realized. In fact, that is our duty. They pivot, right? So what was happening in the courts between the period 1950 and 1970, they pivot by the late 1970s and the early 80s, and they say, no, here we are the saviors of the Constitution. We are here to make a progressive social change happen. It's quite a dramatic ahistorical self-realization, because just 10 years later, 10 years earlier, they were not doing that. So in any event, that's what's happening in the court. What's happening in Parliament is that now the age of stable majorities is coming to an end. So we notice that with with post-emergency governments, the Congress is not quite the political force it used to be. We also have new coalitional political parties, both assuming power and then losing power. And we know that by the mid 80s, except for the post 1984 election, the kind of scale of political majorities has diminished. At that point in time, I think the court consolidates the view that there are limits to political power under a constitutional regime, but these are not limits that we use every day. So the basic structure doctrine is not used on a regular basis. It's still there as a stopgap, and it operates as sort of guardrails of the Constitution, but it's not invoked in kind of everyday political practice or everyday legal practice. It's there. People know it's there. Its legitimacy sort of begins to grow. People say, oh, yeah, we can see a place for that after 1977, because now we know what an emergency looks like. So maybe the court was right in 73 to talk about this possibility. In an ironic sense, the political misjudgment of the Indira Gandhi regime confers sociological legitimacy on the basic structure doctrine, right? I mean, almost like you did exactly what we thought you would do. Is what confers the kind of legitimacy on the basic structure doctrine. I want to just say one line. Did it save India's democracy? I suppose that if you take the long view and you look at it across decades, I think that it plays a significant, it has a significant normative constraining effect on the nature of politics in India. And to that extent, that claim might be deserved, but certainly not in the decade of the 1970s.
Mm-hmm. Yeah. It's been 47 years since that doctrine was laid down. Could you talk to us a little bit about how the courts have expanded on that doctrine? I mean, even in the original judgment, they're not really agreeing on what constitutes the basic structure. But since then, we've had various other judgments and judges weigh in on what they think is part of the basic structure, and in many ways expand what falls within that kitty. So could you talk to us a little bit more about today, what would be an expanded definition of what falls within the basic structure, and how the Supreme Court has engaged with, I mean, I think you've already spoken about that, how the Supreme Court's engaged with that doctrine, but how has it expanded the definition?
So let's do this quickly, because I don't want to wade through the thicket of cases and doctrine, but let me say a few things which give us a general pattern. The first and important point is to recognize that at least till the 2000s, the basic structure doctrine was not invoked often. It's only after late 90s, early 2000s that the basic structure doctrine gets routinely invoked in many cases. What work does it do? It hasn't had to, at least in the courtroom, somehow prevent a coup or prevent an emergency of any sort. It's not had to do that kind of work, but it has been applied in a few cases. What's important, and I'll just make 2 points of expansion and then talk about its political effects, which I think are much more significant than its legal effects. The two expansions that we can recognize is that the court now applies the basic structure doctrine to ordinary legislation, to ordinary executive action, as well as to constitutional amendments. So it's expanded the range of applicability. This is important in legal terms, but what it's also done is it's expanded the range of features, right? The basic features of the Constitution. It's made it clear that federalism is a basic feature of the Constitution. It's made it clear that secularism is a basic feature of the Constitution. It's also made it clear that the independence of the judiciary is a basic feature of the Constitution. So these values have been invoked in a few cases. Now, those are its legal effects. is it significant? Yes, it's significant because I think in a large democracy, large constitutional democracy, invoking this kind of special power, the Indian court has done it more consistently than any other jurisdiction in the world. So it's, in that sense, it's both special and important. But the real effect has been a political effect. I think what is we can have a test for any doctrine. When is a doctrine, constitutional doctrine, part of a constitutional ethos of a nation? And this is the way I would put it, is that if it constrains two majority governments on opposite sides of the political spectrum, which is that people who would initially oppose the doctrine then come back and claim the doctrine. And that is exactly what happened when the first NDA government came to power and constituted the National Commission to review the working of the Constitution. Initially, when the commission was announced, it was unclear what the scope and power of this commission would be. And then there was an extended debate, both in the opposition, in the media, as well as within the alliance that made up the NDA. And it was the initiative of one of the NDA partners that ensured that the terms of reference of the National Commission included a restriction that all changes recommended would be within the scope of the basic structure doctrine. The moment that that change was introduced, it operated as a binding constraint on what was then a coalition government. And as you can tell, as political majorities in India have grown, we are yet to witness any strong move to amend away the constitution. And so I think there's some normative recognition across the political aisle, at least for now, that the basic structure doctrine operates as a constitutional constraint. And that is pretty significant. And I'll just punt to a contemporary point, which is that, looking at what's happening in the US in 2020 and 21, many commentators have pointed out that it's US judges, no matter who appointed them, who have consistently upheld and applied election law and constitutional law, which has meant that whatever has happened in the US has not gained legal legitimacy, right? And my sense is, to the extent that courts and doctrines, and people may think this is all inane stuff, people just talking about stuff in black robes, to the extent that this kind of legal behavior has larger effects on political behavior and the experience of societies, it's fair to say that the basic structure doctrine has had the same effect in India, but not because the court has struck down some large amendment. It's because the political class across the political aisle have used the basic structure doctrine as a guardrail to what is legitimate political action.
Mm-hmm. I mean, that obviously brings a question to mind, which is the judiciary is a non-elected, unaccountable body in many ways. And how fair is it to keep this body in charge of, or to have this body prevent an elected representative accountable body from changing the constitution? And again, like we've spoken, the interpretation of what falls in the basic structure depends on the judge. And given the non-representativeness of the judiciary in India, how would you respond to this criticism that the doctrine just places power in a body that shouldn't have this much power?
So I think this argument, and I think it's good that you raise it, because it gets canvassed often, and I suppose that our 6th and 10th standard civics books do a bad job of explaining and helping us understand what political values we have chosen. So India could have been just a parliamentary democracy, and by that I mean just a democracy that counted the number of votes and decided who gets to make legislative and executive decisions, and the majority wins at all times. And we didn't make that choice. The choice we made was to be not just a democracy, but also to be a republic, and to be a constitutional democratic republic. And the moment you line those three terms up in that order, the terms that sandwich the idea of democracy operate as limits on the democratic principle. If the democratic principle is one person, one vote, and broadly the majority vote decides political and executive power, the other two values, constitutionalism and republicanism, operate as constraints on the democratic principle. And constitutionalism, at the very least, requires that an unelected branch of government operates to enforce the Constitution. The Constitution makes both procedural and value-based limits on democratic power, and republicanism confirms that individuals have a right to participate in the process irrespective of whether they're majority or minority, right? So the Republican value of conferring on individuals that dignitarian power, that every individual is important, that civic republicanism is the credo of the nation, as well as the constitutional limit, is where judicial power emerges from. So my sense is that usually the objection to a basic structure principle, or for that matter, to any judicial review, is an objection that rests on a conception of democracy as a standalone political value. And the moment we recognize that we have a cluster of values that we have adopted in 1950 as being the values of our political life, this problem moderates. Now, I wouldn't for a moment suggest that this makes the judiciary the most powerful branch. I think we know enough to know that the judiciary doesn't have quite that amount of clout, and in recent years hasn't even used the clout that it has. So, so in that sense, there's no real fear in an Indian context that somehow the judiciary overrides all other political branches. But its role as kind of keeping the boundary lines of the nature of the democracy that we want to protect is very important.
Yeah. So given that the judiciary does have this guard railing power, do you think that could change? Somebody in the audience has also asked this question, which is, can tomorrow a 15-judge bench be constituted and overturn Kesavananda Bharati, overturn the basic structure doctrine?
So I think we might want to ask the question of possibility in two senses. What is legally possible, and then what is politically possible and normatively possible, right? So as a matter of legal possibility, clearly the strength of the Supreme Court has grown. We have 40 plus judges in the court. Constituting a 15 or 17 judge bench is within the bounds of possibility. It's not impossible. Is it likely? It's unlikely. It hasn't happened from 1973. There was a move, I think, a few years ago to refer a particular decision to a larger bench, but that has not happened. So we haven't seen that happen across what is it, 30 plus almost 50 years. We're running up to 50 years now. Does that make this legally impossible? No. But as we know that we work in precedent-based systems, with the passage of time, the legitimacy and the value of particular forms of doctrine get encrusted, you know. And so the legal possibility exists, but it's slim. It's the political possibility that we might want to think about more carefully, which is that clearly what constrains politics is a sound understanding of constitutional values and the place of constitutionalism in our collective lives. If political movements see the Constitution as somehow being antithetical to their political projects, and somehow just being so orthogonal to their political values, then the pressure for this kind of bench constitution will increase. My sense is that the real challenge of our times and arguably all times is to find that constitutions as documents have the ability to embrace a wide range of political views. All constitutions have this. So too does the Indian Constitution. It is not fenced off such that this or that political movement cannot somehow find its voice within a constitutional frame. So political possibility exists, but I would say that so long as there's enough both political and interpretive creativity to espouse whatever political choices and political preferences we have in constitutional terms, then I think we have no reason to dislodge a constitution like ours. And maybe I'll just say one last thing, which is that making constitutions and making constitutions that endure is a very difficult activity. South Asia doesn't have a glowing record. India stands out in this regard. Arguably, India stands out in the post-colonial developing world for the robustness of its constitutional traditions. So I sense that a popular and social understanding that we've been good at this. We've not been very good at developing our economy. We have not been very good at developing efficient government, but we have been quite good at maintaining a constitution. So if we are able to appreciate what we're good at and understand what we're not so good at, then maybe we develop an appropriate balance. So in that sense, political possibility would rest on our own senses, our collective senses of judgment of how we've done so far.
Mm-hmm. Yeah. I think the fact that that doctrine and that judgment, while acting as a constraining power, also gives enough breathing room, like you said, for different political views and different government actions to function legitimately within that doctrine, makes me believe that that's politically not going to be a path that anyone goes down. I'm quickly going to go through some of the audience questions now. Someone wants to know, where do you think the limits of the basic structure doctrine should lie? Does the court have to define the boundaries? When do we say a new value is now part of the basic structure? And should there be limits on what the court can say as part of the basic structure?
And let me just use a contemporary example to respond. I suppose that in the last 3 to 4 years, we have some serious challenges around questions of common dining, marriage across castes, across religion. These are questions that are captured in the Constitution under a value of fraternity, which was deliberately chosen and motivated with a very sound understanding of the nature of Indian society and the reasons why Indian society is not fraternal, right? And now let's imagine for a moment that some of the cases that are pending in the high courts and have wound their way to the Supreme Court get challenged on these grounds. Can the Indian Supreme Court announce that fraternity is a basic feature of the Constitution and that ordinary legislation and executive action must promote fraternity and not limit it? I think that's entirely possible. It's entirely possible because a court is something. So let me put it like this: a court is a sort of a refraction device. There are abstract values that are stated in the Constitution. There are actual lives that we lead and political and social contexts that we inhabit. The court is our institution of choice, of design in the Constitution that reflects on these values and makes it work in particular case contexts. That is the role of the court. The basic structure, and just to be clear, the court does this in all cases. It doesn't do this only in basic structure cases. It does this in all cases. This is the role that we give the court in a constitutional democracy. So it's entirely possible with the right cluster of cases at hand that a court will say that fraternity, they've never said so far that fraternity is a part of the basic features of the Constitution, is part of the basic structure of the Constitution, but they may well say it because the issues of the day require the court to revisit this value in a particular sense. So as long as the court discharges or applies the basic structure doctrine on a case-by-case basis, I think it's well within its powers. I think that is its limit. What it cannot do is it cannot write a new article of the Constitution. It cannot amend the Constitution. What it can do is it can decide the case at hand, and it can decide the case at hand interpreting the Constitution, which is its structural role. This is how I would describe the limits of the court. Some, and I think some lawyers and maybe some non-lawyers might say that this is whimsical because it's not a limit at all. I don't think so. And I think that the constraint of the court is a narrative constraint, which is we have said some things about how we do the basic structure doctrine, and we follow what we have said before because we follow the rules of precedent. That is a narrative constraint on what the court can do in the next case that comes before it. And this is a meaningful and real constraint, as in any other case.
Mm-hmm. Yeah. And I mean, locating the court within the socio-political trends of the time, right? The court and the judges aren't separate from it. And they're not going to be a countervailing force if the other forces are too strong in some ways. And that's important to keep in mind. Just a couple of more questions. I think we're almost at time. Does any other country have this understanding of a basic structure?
So what's interesting is that when the Indian court developed the doctrine, it was slightly outlier. And over the years, the acceptability of the doctrine has grown. Quite remarkably, recently, the UK Supreme Court in the Brexit conversation was willing to countenance the possibility that there might be real limits on parliamentary power to make particular forms of law or amend some kinds of laws. This is remarkable for a common law court in the UK to be saying, where the doctrine of parliamentary sovereignty emerged from historically, right? So it's in a sense, here is an example of a doctrine that emerged from the colonies and has traveled back to the metropolitan core. The doctrine has found reasonable acceptance in parts of Asia, as well as in parts of Africa, in very interesting ways. It would be a mini lecture to to figure out all the ways and means in which basic structure doctrine has traveled. But I think it's as a general point, I'll say that today it's not an outlier doctrine. It's taken seriously, and the idea that constitutions may impose meta limits on amending power is taken quite seriously. Can I just say one other thing, Shruti, which I think is useful? I think what we have to understand is that the idea of legal limits on amending power is a very common law, Anglo-American idea. Continental Europe, especially the German constitution or post-war constitution, embraces the possibility that there might be limits to amending power. Now that might come from the German historical experience and the failure of the Weimar Republic, but that idea is not intellectually or politically controversial. So we're not outliers there too. So between the German constitution and the Indian constitution, we would find broad resonance. So it's often made out as if the basic structure doctrine sticks out in the constitutional universe, and that's not quite the case.
Mm-hmm. Yeah, the most striking example that I've read of the basic structure traveling is in Bangladesh, where in 1989 they directly quote Kesavananda Bharati and passes the judgment for it.
Yeah, Bangladesh, Pakistan, Sri Lanka, all Nepal. So the Kesavananda has traveled well. It's got easy visa access, and you and I can't go to Pakistan today. The doctrine travels well.
Well, I'm glad you mentioned that because we're at time. And to conclude with, I want to ask you what happened to Kesavananda Bharati. So he files this case, becomes a very important figure in the life of lawyers, at least. And what happens to him after the case? He's pretty young when the case is filed. I think about 18 years old.
Very young at the time the case is filed. So what's striking about the way the decision was crafted in Kesavananda Bharati is that he didn't get any real relief. I mean, he had lands at stake and he wanted to challenge state legislation that deprived him of his lands. And the court put in place the broad basic structure doctrine, but didn't give him the relief that he was seeking with respect to the ninth schedule and so on. Now, I think I don't know if any of the obituaries, and I'm sorry, I haven't had the time to look at all the obituaries to track whether the executive action finally deprived the Matha of its lands or not. I'm not sure. But as a legal matter, at least as far as the Supreme Court was concerned, he didn't get substantive relief. He kind of won the big prize, but when it came to the details, the court left him a bit dry.
Okay. With that, I think we're at the end of this session. Thank you everyone for attending. Thank you, Sudhir, for what has been a very enlightening 1 hour. And thank you to BIC for giving us the platform to host this talk.
Thanks, Shruti. Bye.
Kesavananda Bharati versus State of Kerala has been oft heard in certain kind of conversations without the underlying meaning of it being known or fully understood, including the part of the accidental litigant. Thank you for walking us through and demystifying this landmark judgment and helping us make sense of the heft and the depth of it, and for breaking down the basic structure doctrine for those of us who may not be aware and may do well in having a necessary primer such as this. Thank you for your time and expertise, Shruti, and of course, Sudhir, thank you for your time and for your scholarship and for that fantastic approach that you have to breaking down a concept. Thank you, audience, for joining us, and see you next time. Good night, everyone.
Thank you, Lekha.